Another installment of Martial Law with attorney Marshall Chriswell. And this program is intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And certainly Marshall Chriswell fits that bill. Good morning.
Good morning.
Good to have you with us here this morning. Your voice is echoing like you're in a brand new chamber, far away from where you once were.
Yeah, we've moved into our new office suite here in the RMP Cole building. So I'm in a little bit of a bigger space. It's nice we were in the atrium building, which was a very nice space, but it was in the lower level. So now we have windows and a lot of light, and I think everybody's gonna really enjoy it.
What floor are you on?
We're on the third floor.
On the third floor, and main entrance will get you there.
That's right. You can come through the front door and make a right around the corner to the elevator up to the third floor, and I'm right there. You can also there is an entrance from the rear of the building, which there are no stairs at all, just right onto an elevator from the parking lot, third floor, and I'm about 2 doors down from the elevator. So very good for wheelchair access, things like that.
And we'll repeat this at the end of the segment, but folks should know that your phone number is the same, correct?
Phone number is the same. Phone, fax, email, all that stuff is the same.
Very good, very good. So let's get into a couple of different topics, or at least one of them today. No telling how long this will take. The topic, civil discovery, which has to do with the lawsuit that is filed, and both sides want to know what's going on and what information does the other side have. Would that be a thumbnail of it, or even less?
Yeah, absolutely. So in modern civil practice, you really can't hide the ball, okay? There aren't these crazy aha moments in court. There are very few surprises happen at a trial, and the reason for that is both sides going into a trial basically know what the testimony is going to be from the witnesses and what evidence is going to be presented. Now, there are always little surprises, of course, along the way, but the main the claims that are being asserted and the testimony and evidence to back them up are all generally fleshed out through the civil discovery process.
All right, so give me an example and pick a type of case, a property dispute or some other dispute between two parties. That lawsuit has been filed. Give me an example of what discovery would entail.
Sure. Let's just take a personal injury case, okay?
Okay.
Somebody has sued you and said that you you caused an accident that has caused them an injury. They've suffered physical injury that requires payment of medical expenses, pain and suffering, lost wages, things like that. So you're served with this lawsuit. You go through the pleadings phase, all right? You receive the complaint. You file maybe preliminary objections to some of the claims, and you file an answer to the claims, and the pleadings process plays out. After the pleadings process is done, where we're asserting the claims back and forth, then we move into discovery, all right? So what kind of discovery? What information do I need to get in order to defend myself against this lawsuit? All right, number one, I'm going to send written interrogatories. All right, so I'm going to send requests. They are essentially interrogatories or questions to the other side that they're required to answer. Everything in discovery is done under oath. So they're required to answer these questions under oath that can be used later, right? So this establishes what the facts are from the other side, and those can be used later then at trial if the story changes, things like that. So, for example, an interrogatory in a case like this may be, okay, you're saying you suffered injuries. Describe the injuries that you're suffering with particularity. You know, describe exactly what's going on. What medical bills have you incurred? what witnesses do you have that you're going to present at trial? Fact witnesses, somebody in the car with you. Is somebody, is there a bystander witness? Do you have expert witnesses, doctors, witnesses that are going to recreate the scene of the accident and present, how the accident occurred? What types of witnesses are you going to have? So interrogatories would be the first thing that you're thinking of.
Mm-hmm.
Okay. Next, you're going to send these all generally are sent together, but you're going to send requests for production of documents. In every case, almost every case, it's very important to get documents from the other side that are relevant to their claims. So in this case, in our hypothetical car accident personal injury case, you're going to be requesting medical bills. You're going to be requesting communications with their insurance company. You're going to be requesting the reports, any expert reports if they've got, whether it's police reports they've received or reports from doctors regarding what their injuries were and what their prognosis is, correspondence, emails, letters that they've received, and in some cases, big civil cases, class action cases,
mm-hmm.
There can be electronic discovery of millions of emails when you're talking about particularly large corporations. So get away from a car accident case and go on. Think about a product liability case. And you're requesting all documents related to the manufacture of this particular product. These can be millions of emails, hundreds of thousands of them, and there are attorneys that just specialize in reviewing these documents. They sit all day in a high-rise building in Pittsburgh and review emails and click on them for 12 hours a day.
Mm-hmm.
This discovery, especially electronic discovery, can get huge.
Mm-hmm.
But in our car accident case, those are the kinds of things you'd be requesting.
Yeah. Would you be able to, as an attorney of someone who is being sued for having allegedly caused something to happen that injured somebody, would you be able to go back into their previous medical history to see if they had a pre-existing condition?
So another type of discovery, and yes, absolutely, through interrogatories and through requests for production of documents, you can get to, yes, you can go back and say, all right, did you have a previous back injury that maybe was just exacerbated by this, and it wasn't necessarily caused by the injury. Mm-hmm. The other thing that you can do is through the discovery process, you can make a request for the plaintiff to submit to a physical examination. So you say, all right, plaintiff, you say you were injured. You have your doctor who says that you were injured and you can't work again, or your earning capacity is severely diminished, and you have all these injuries. Okay, well, now go to our doctor. All right, let's agree on another doctor, and you're going to go, and we're going to request that you submit to a second physical examination. That's another type of discovery.
Okay, all right. And we're talking here about personal injury. In other types of lawsuits, would there be other types of discovery, or would it be about the same?
So another type of discovery that can be used in any lawsuit is a request for admission. You can essentially request that the other side admit certain facts that are necessary to prove your claim. For instance, if we're in a car accident case and I've been sued and I send a request for admission to the other side, and I say, well, the accident, the car that was involved was a blue Chevy Nova. All right, well, I'll send you a request for admission. Were you driving a blue Chevy Nova, license plate ABC 123, on August 8th, 2017?
Mm-hmm.
And so that they have to answer that. And again, that's under oath. So you can prove a lot of the elements or some of the elements of your claim whenever, so that moving forward, you don't have to worry about going and actually obtaining additional evidence. All right, how do I prove that they were the ones driving this car, or whatever?
Yeah.
So it's so requests for admissions are another one, and then another type of discovery, and a big one, is oral deposition. So I can send a notice of deposition to the other party or to any witness, relevant witness, and actually have them sit down, in my office with a court reporter and question them regarding the incident. And these, the depositions can be hugely helpful, right? You end up with these transcripts which basically tell you what the testimony is going to be at trial from that party or that witness. Mm-hmm. And so it helps. Discovery is extremely valuable in settling claims, right? Once you have a full idea of what the trial is going to look like, you can start to get an idea of what the outcome might be, and then you can settle. Also, it's very helpful if the story changes, right? If the witness says that that they had a particular injury, and they say this in their deposition, and they get to trial, and the story changes. They say something else, or they say that they that they went through the light and it was green during deposition, and then you get to trial and they say that it was yellow, or so when they change the story, then you've got the transcripts from that oral deposition. You say, no, 2 months ago when you sat in my office under oath, you said that the light was green. So that's the scope of what discovery is in a civil case.
Yeah, I would guess as well then that somebody who says that they were not using their cell phone, you through discovery find out that they were, that has a big impact on the case as well. Things of that nature. Absolutely, and those are the details that start to come out, right? When I receive a complaint, so somebody files a lawsuit and the client brings me the complaint, all those things aren't in there. It just says, we were traveling this direction this time of day, and this incident occurred, and I suffered injuries. Okay, what are the details? And you start to flesh out the facts of the case through discovery, and if a bombshell comes out like that, right, that somebody was on their cell phone, then that's something that can really change the complexion of the case. So an attorney, give me your opinion here. If an attorney has strengths or weaknesses in their game, like a fastball pitcher has a good fastball but maybe not so good a curveball, would there be attorneys that would be better at discovery than some other attorney, or not as diligent or more diligent than some other attorney?
Everybody has strengths and weaknesses, absolutely. Talking about those oral depositions, where you get a client or you get a party or a witness in the conference room with the court reporters and the other parties and attorneys are there, and being able to control the direction of that deposition and get the information that you need to get from that witness it's a skill, and it's a skill that's honed over time, some attorneys are definitely better at it than others. We're all trying to improve every day.
Yeah. Then I would guess that there would be ways to find out that this attorney was really good for me, and most of that would probably be word of mouth. I would assume.
For the most part, yeah, you can do all the advertising you want, but word of mouth really is gold when it comes to attracting clients, because that's where your reputation is built, on the success that you have.
All right, very good. So, for somebody who wants to avail themselves of your services in your brand new office, give us the contact information again.
You can call me at 724-465-5826. Go online to www.westernpalawyer.com, or, like I said, come see us in the R&P Cole building on the 3rd floor.
Very good. Attorney Marshall Chriswell, thanks for spending time with us today.
Okay, thank you. Have a good week.
You too. We'll see you.
Bye.
You too. We'll see you.
Bye.
You too. We'll see you.